Hello everyone, I am Gurudutt. This is the third video of Professional Ethics, Accountancy of Lawyers and Bar and Bench Relation. In this video, we will be starting Contempt of Court. We will be completing Contempt of Court in two videos. In this video, in the first video, we will be looking at the definition of Contempt of Court, how it has historically evolved, what are the reasons for this law, and the constitutional provisions in the Constitution of India which support this law. Currently, the first thing which comes in our mind while hearing the word contempt of court is Prashant Bhushan's case. In the recent case, Supreme Court fined Prashant Bhushan ₹1 for scandalizing the process of administration by his two tweets. So that's a current issue and you all must know about that case. Please go and search news blogs, the court case, find the judgment of that case and study it. Now let's study what is contempt of court. The word contempt originated around 13th century from the Latin word contemptus, which means scorn. The meaning of scorn is utter disregard for someone, disrespectful to someone or something. Oswald defines contempt to be constituted by any conduct that tends to bring the authority and administration of law into disrespect, disregard, or to interfere with or prejudice parties or their witnesses during litigation. So, as per Oswald, if you are anyhow disrespecting, disregarding, or interfering with the process of justice during litigation, then that should be contempt of court. Halsbury defines contempt as consisting of words spoken or written which obstruct or tend to obstruct the administration of justice. So it is not only spoken words but even written words which can cause contempt and obstruct the administration of justice. While Section 2A of Contempt of Courts Act 1971 says contempt of court means civil contempt or criminal contempt. It defines contempt of court only in one line. It can either be civil contempt or criminal contempt. Section 2A of Contempt of Court Act 1971. Do remember the act and the section. Often legal luminaries have said that this definition is not sufficient and it should be amended and a broader definition should be given. Now let's see what is civil contempt and what is criminal contempt. Civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to court. So, if you are not following any order of the court, if you are not following any judgment of the court, decree of the court, writ of the court, then you are doing civil contempt. So, for example, court passes an order to you to pay a minimum maintenance or pay taxes on time, or to pay taxes to the government, and you are still not paying the taxes, then that will be a civil contempt. For example, a court orders university to conduct exam and university still is not conducting the exam, then that will be a civil contempt. Now let's see what is criminal contempt. Section 2C, subclause C defines criminal contempt. Criminal contempt means the publication, whether by words spoken or written, by signs or by visible representation or otherwise, of any matter or the doing of any other act whatsoever which, now after which you have to see there are three headings given. Do remember these three words: scandalizes, prejudices, or interferes. Which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court. Which prejudices or it interferes or tends to interfere with the due course of any judicial proceeding. Interferes or tend to interfere with the obstruct or tends to obstruct the administration of justice in any manner, in any other manner. So while civil contempt is disobeying the court, criminal contempt is scandalizing, prejudicing, interfering in the administration of justice or judicial proceeding through by words spoken or written, or by signs, visible representation, or otherwise. So this is criminal contempt. Now let's see, why do we need such law? So when we see the evolution of state, nation state, it evolved around king. King was seen as a center around which the whole state or the whole kingdom, whole nation revolved. So he was not only the executive head, not the executive center of power, he was also judicial center of power. So if somebody disobeyed the order of king, it was seen as a utter disregard not against only king but against the whole concept of state, and therefore he was punished severely. So slowly, when the democracies evolved, the power of king, the judicial power of king, was transferred to the courts. Earlier, king was executive as well as judicial function, judicial head. Now, with the evolution of state, democracies came into picture. When democracies came into picture, the judicial power of king was transferred to the judiciary. The executive power was transferred to the executive head, like prime minister, president. So, judiciary got the power of contempt, so that if somebody disobeyed the judiciary, it was like disobeying the earlier king, and therefore they were punished severely. Even in the feudal system, from kingship we developed a feudal system. In feudal system also, the system around the whole state revolved around the king, and people were subject. So subject, if they criticized the master, for example, if in a democracy, earlier before the democracy we had kingship. In kingship, people were serving the king. In kingdom, people were serving the king. While in democracy, king is serving, the executive head is serving the people. So there's a basic difference, but still the power of contempt is still withheld with the king or the judiciary. It is similar to that, where the king was supreme and people are subject. So subject could not criticize the master. If he does so, he will be punished for contempt. The whole civil society is founded in respect of law, in respect for the law. If people are not respecting the law and choosing to break the law, the whole society will crumble. Law enforcing agency, that someone ensure the freedom recognized by the Indian Constitution. So if you are not following the law, if everyone is breaking the law, the whole legal system, the whole society will crumble. Therefore, it is very necessary to follow the law. And therefore, the power of contempt of court has been given to judiciary, so that if somebody is not following the law, judiciary can punish them and make sure that everyone follows the law. Also, it protects the seat of justice. The contempt of court protects the seat of justice and not the judge. So, if you are criticizing a judge or scandalizing a judge in his personal capacity, then that will not be counted as contempt of court. But if you are scandalizing or criticizing the judge in his judicial capacity, then only it will be contempt of court. Mind it. If you say that this particular judge is corrupt, I want to file FIR against this judge, then that will not be contempt of court. It will be contempt of court when you will say that this particular judge has taken money to give judgment in this particular case. Then that will be interfering with the process of administration, and therefore that will be contempt of court. Understand the minute difference, the grey line between these two examples. Criticizing a judge, for example, in Prashant Bhushan in 2008, when his father Shanti Bhushan was alive, they made a document public, in which they claimed that half of the last 8-9 judges, chief justices, were having property disproportionate to their income. They made that a public document. Now, a contempt of court case was filed against them. So they just said that we are not criticizing the justice, the seat of justice. We are not criticizing the Supreme Court. We are just saying that these particular judges, in their personal capacity, have more income than what they should have, through the legal means, by the legal means. So this was the matter is still in the court, but more or less it was seen as a attacking judges in personal capacity, and therefore it was held not to be contempt of court. What is the objective of such law? to define and limit powers of certain courts in punishing contempt of courts, and to uphold the majesty and the dignity of law courts and their image in the minds of public, is no way whittled down. So basically, the whole law is to make sure that the prestige of court, the respect of court in the minds of public, is not decreased. People should respect the seat of justice. They should not question its significance or its integrity unnecessarily. People should respect it, and therefore we have such law. Now let's see some constitutional provisions. You don't have to learn all the constitutional provisions, but do remember the articles. That is important. The first important article is 129. 129 says that Supreme Court has to be the court of record. By the court of record, and if any court is court of record, then that court has the power of contempt, power to punish someone for contempt by default. The Supreme Court shall be the court of record and shall have all such powers that the court can punish for anybody to anyone for contempt of itself. Then similarly, by Article 215, High Court are also court of record. Then comes Article 144, civil and judicial authorities to act in the aid of Supreme Court. All civil and judicial authorities in the territory of India shall act in the aid of Supreme Court. So by Article 144, it is obliged on it is the obligatory of all the civil and judicial authorities that they should follow the orders of Supreme Court. And if they don't follow, by the virtue of Article 144, Supreme Court can punish them. Article 141, law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. So there, by the virtue of this article, Article 141, there are two kinds of laws which are followed in India. First is legislative law, that is passed by the state legislature or parliament. The second is judicial law, that can be passed by the Supreme Court and similarly by the High Court. So there are two kinds of law. Article 142, again this is a big article, you can skip it. Still, enforcement of decrees and orders of Supreme Court unless as to discovery. The Supreme Court in the exercise of its jurisdiction may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it. So Article 142 is one of the most powerful articles Supreme Court has. Supreme Court can literally pass any order by the virtue of Article 142. So even if something is not, for example, something has been done and under the Contempt of Courts Act, which is a legislative creation, Contempt of Court Act 1971, that particular thing is not contempt. But still, by the virtue of Article 142, if Supreme Court thinks that that event or that statement is a problematic statement, then Supreme Court can pass any order under the Article 142. It is one of the most powerful articles Supreme Court has. Then Article 261, Public Acts, Record and Judicial Proceeding. Full faith and credit shall be given throughout the territory of India to public acts, record and judicial proceedings of the Union and of every state. The manner in which the condition under which the acts, record and proceeding referred to in clause 1 shall be proved, and the effect thereof determined shall be as provided by law made by the Parliament. Final judgments, now this is important, final judgments and orders delivered or passed by civil courts in any part of the territory of India shall be capable of execution anywhere within the territory of India according to the law. So by the 261 clause 3, if any civil court is passing any order, then that order has to be followed in any part of India. For example, if civil court of Noida passes some order to be followed in Ghaziabad, now the Ghaziabad authorities said that we will not follow order of civil court of Noida, and that would be a very problematic matter for India. So therefore, because India is a big country, and therefore if Ghaziabad authorities do not obey the orders of civil court of Noida, then also civil court of Noida can start contempt proceeding. So the local courts have been granted contempt power somehow through this order, through this article. Now, what are the objectives which were achieved by the Indian Constitution? The spelling is wrong. Indian Constitution. The objective achieved by Indian Constitution through the articles such as 129, 141, 142, the dignity of court has been maintained, while free and positive criticism are still allowed by the virtue of Article 19. Guidelines of the law, reasonable limit to the freedom, the restrictions imposed in Article 19 gives the reasonable limits. Right to reputation and privacy have been upheld. Willful non-compliance will be punished, and reasonable limit on trial by media. This is again very important. By the virtue of Article 142, generally courts pass order on curbing the media from doing media trial. Exactly what is happening in Sushant Singh Rajput's case. Media is doing the trial. So if Supreme Court or High Court passes some order, it will be doing so under the power of Article 142. Supreme Court under Article 142. Thank you. In the next video, we will further continue contempt of court.